Greetings, this is Chapter 12, Age Discrimination, and we're going to talk about the Age Discrimination and Employment Act and other state-based age discrimination laws and how they are slightly different from some of the Title VII protections. Remember, age is not protected under Title VII, but age discrimination is protected under a separate employment law. And it has some parallels to some of the Title VII stuff, but it's slightly different. So we'll spend some time talking about protections under age and some of the stereotypes that go along with it, and understanding how important it is to ensure that everybody who can work should be working. We have about 11 learning objectives in this chapter. Number one, to differentiate the reality of the value that an older worker could bring to the workplace from the bias that permeates some of our perceptions of them. And there is a longstanding bias with individuals who believe that older workers are not as willing to learn new skills, new technologies, and that's not the case. Like any stereotype, it's important to remember that not everybody follows the stereotype. Now, stereotypes come from some common characteristics we see in people or attributions people make that are not necessarily based in reality. But nonetheless, we know that our older workers are more than capable of doing work, and we'll have interesting stories to tell on that. We're going to describe the history of protecting older workers in the U.S. and what the parameters are for that. We're going to talk about the ADA and how that compares to other state-based age discrimination laws. We're going to identify the legal options available to somebody who believes that they are a victim of age discrimination, and we'll talk about the prima facie case and how that is slightly different than the prima facie case obviously made for other Title VII laws and protections. We'll talk about what it means to have a bona fide occupational qualification defense when it comes to the ADEA and how that is limited. We're going to explain the difference between situations where disparate impact and disparate treatment apply in connection with age discrimination. We're going to talk about the factual circumstances when an employer's economic concerns may justify adverse action against particular groups of workers. So there are some circumstances where we can make an economic decision that says we are going to lay off people because of economic issues, but we have to be particularly careful about how we manage that. We're going to talk about the necessary elements to determine what is considered pretext under the ADEA. And what we mean by pretext is even though on the surface it may look like I'm making a legal decision, it's really a pretext for discriminating against somebody because of age in this particular context. Obviously, we can have pretext when it comes to race and any of the other areas that we have protections, but specifically we'll talk about pretext with respect to age discrimination. And then finally, we'll talk about defining the parameters of a valid waiver of ADEA rights. And there are some situations where we can have a waiver of our rights and people can waive them, but only under certain circumstances. Our Exhibit 12.1 in the textbook highlights the statute that protects workers from age discrimination, and it reads as follows: to fail or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privilege of employment because of their age. To limit, segregate, or classify employees in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's age, or to reduce the wage rate of any employee in order to comply with this. So that's all part of the Age Discrimination and Employment Act, and if you recall, it's anybody 40 or older that is protected under the federal statute. Now, there are some state statutes, as we'll get into, that are slightly different. They actually expand the age range for discrimination, but nonetheless, for the federal statute, it's 40 or older. And this is very distinct from the Civil Rights Act of '64. The interpretations of prima facie case and BFOQs are very different. or moderately different. So we want to make sure that we parallel, right? We parallel them. So the terminology is the same, but how it applies to age discrimination is a little different. In terms of understanding the context within which age discrimination is being defined and is being investigated, we know that American culture absolutely values youth over age and wisdom. Other cultures value aging. They value their aging relatives. They honor the knowledge that older folks have. In the United States, our culture is very much a youth culture. And so, of course, that results in an enormous amount of stereotypes about what someone can or can't do regarding the energy they may have, the innovation that they can bring to the table, any sort of what their interest in productivity is. And that's not the case for everybody. And I will retell the story that I tell often to folks. My father-in-law was first married, obviously, when he was in his 20s. He had a second marriage later on when he was in his 50s, and he had young kids in his 50s. And so now, as somebody in his 50s with young kids, this was in the mid 60s, he was looking for work that would be more stable, that would provide a regular income. He worked for years in real estate in New York City, and he made a decision that he wanted to continue to work in a more solid job. So he applied for a job at Rite Aid Corporation to be their senior VP of real estate. Rite Aid at the time was a small regional a drugstore, and they wanted to expand across the United States. So he applied for the job, and what his job would entail is traveling to different locations, scouting out potential locations for expanding Rite Aid across the country, and ultimately setting those up, doing the real estate deals, and then letting the organization expand appropriately. So he applies for the job, and this is before the ADEA went into effect. And he said, I'm looking for this job. This is my experience. This is what I want to do. And they're like, Lou, you're old. You're going to retire in a few years. Why should we hire you? Why would it matter? I mean, you're going to be old and you're going to retire and we're not going to care. And it's like, he said, number one, I don't plan to retire if I don't have to. Certainly, I want to be able to keep working. I have a young family. It's important for me to make sure that they are taken care of financially, et cetera, et cetera. So off he goes, talking to them about that. And he said, ultimately, in the end, he says, I want to work till the day I die. He says, I love working. I love being able to contribute. I love being able to, um, to innovate. And he says, and I know I'm the best person for this job. And of course, they ultimately hired him, right? That's the long story, right? They hired him, and he was in his, I guess, mid to late 50s at that time. And I will tell you that he worked full time for them until he was about 82. So it was about 30 years that he worked for them, about 25 years worked for them, expanding Rite Aid Corporation across the planet, across the United States. So they're all over the place, largely because of him. And he then retired, and he took on a consulting job with them where he was involved in renegotiating leases and things like that. He did that on a contract basis, and he died just short of his 90th birthday. He was 89 years old, and he was still giving work orders to people on his deathbed. Take care of this contract, do this. This is a gentleman who also, when computers became the norm, desktop computers in the early 80s, where people started having computers at their desks at work that were no longer mainframes. They were now going to be computers on people's desks. He went out in his late 70s and early 80s and bought a computer and learned how to use a computer. He taught himself that. He was willing to innovate. He was willing to do what it took to do the jobs. So those stereotypes are not uniform, and you have to judge each person on their ability to do the work and being willing to put in the time and the energy and the innovation into doing any kind of job. So it is important that we make sure we absolutely, absolutely judge each person on their merits. Now, IT industry has clearly got some ageist issues, and like you've got Zuckerberg's speech, right, at Stanford University, where he was talking about going to um, work at Facebook, and how he wanted to attract young people, and it was young people that he wanted to have that lifeblood there. And of course Zuckerberg's got his own issues, which we won't get into, but that gives you a good example of how it's pervasive in the IT culture, that we think that older workers aren't going to be able to do the IT innovation that people, or be willing to learn, for IT innovation, and that's not the case. Google also has a problem, and we'll talk about this a little bit when we talk about privacy issues and recruiting issues. But Google had to settle with a former executive, Brian Reed, simply because of they made some assumptions about whether or not he was able to do a job, and there's a lot of evidence out there about advertisement that happens that's targeted advertisement on things like Facebook or Google, or you name it, where it targets people of a certain age for jobs. But the courts found was that that's discriminating against individuals who are older, who would be capable of doing the job. So if you're only targeting a certain age group, you are actively discriminating against older workers who absolutely could do that job. So while targeted in advertisement sounds like it's really sexy and it's really a good idea when it comes to recruiting people, when you do those kind of targeted recruiting, and that's the only area where you recruit, right? You are limiting your pool, and you are effectively discriminating against people who are 40 or older. So that's what happened there. And as you can see from the quote from the EEOC, despite decades of research finding that age does not predict ability or performance, employers still fall back on ageist stereotypes. So let's be mindful about the reality and not the assumptions that we make, or the presumptions that we make based on stereotypes. In terms of additional contextual issues, older workers are staying on the job longer. And baby boomers, that boomer generation, is really changing the notion of what it means to be of retirement age. They are in much better health than their predecessors, the traditionalist generations, and they are capable of doing work and want to work longer. And then, given even the Great Recession in 2008, 2009, 2010, we're finding people who lost a lot of their life savings, that instead of being able to retire at, say, 65, they want to work till they're 70 or 72 in order to continue to save money and kind of go from there. Older workers may be perceived as being more expensive because of their greater experience and seniority, but fundamentally that's not the case. The research suggests that their experience is being undervalued, that they're not being paid what their education and experience is worth, and that we are cutting off our nose to spite our face, if you will, because we're removing people from the workforce who have tremendous amount of skill and ability and willingness to work hard, and we're not paying them for what they offer us. And then if we get rid of them, we lose their knowledge and experience, and all we have are replacing it with people that don't have institutional knowledge, that don't have years of experience to be able to make better decisions about these sorts of things. And so the conclusion, of course, is, right, don't make generalizations, because that's going to create a situation of wrongful discrimination. We want to be in a situation where people actually get judged on their own merits, whether or not they could do the job. Whether you're 20 years old or 40 years old or 60 years old, be judged on your ability to do the job, not on what you presume someone can or can't do because of an age. It's because age is just a number, and it's really all about state of mind and capacity and willingness to do things like anything else. In terms of the statutory basis for age discrimination, it's based on the Age Discrimination in Employment Act, or known as the ADEA. It prohibits discrimination in employment on the basis of age, and it only applies at the federal level to individuals who are at least 40 or older. And oftentimes it gets capped around 70, but generally speaking, most state statutes have an allowance for age discrimination over 70, and in many circumstances from 18 to whenever, and as we'll get into that. Businesses with 20 full-time equivalent employees and all governments are required to protect against age discrimination. Individuals less than 40 are not protected by the Act, and they may be discriminated on based on their age. So you can say you don't have the experience for the job, we need somebody with more experience, or you're not old enough to do this particular job. And we might see that with people who are 18 or who are 16 trying to apply for the job. There really is no upper age under the ADEA. As I said, the states have some limits sometimes on age discrimination, which we'll get into. We noticed around the recession in 2008, 2009, 10, 11, where claims started to increase, very likely because individuals were being laid off during the recession for financial reasons, and so older workers were the first to go. But we're finding that the claims have stabilized. They have actually gone back down again, and it might be simply it was an artifact of the recession. It's hard to know. We'll watch those trends. And very also could be likely based on economic conditions are more stable, and organizations are more likely to engage in arbitration as opposed to going to lawsuits.